My name is Jennifer Kuyrkendall Griffin. I'm running for Suwannee County Judge. In today's installment of Scales, or Suwannee County Access to Legal Education series, I'm going to be discussing the appointment of a guardian advocate. Now, this is one of the most frequent types of guardianship cases when dealing with young adults. Say your young child was born with Down syndrome, and once your child turns 18, he or she is considered an adult under the law despite having a developmental disability. Your ability to take care of all the medical appointments is suddenly gone. So what do? You file a petition for appointment of guardian advocate. Now, this type of guardianship is not like a plenary guardianship where there has to be a finding of incapacity, which I'll be discussing plenary guardianships in a later Scales video. Rather, in this type of guardianship, the court may appoint a guardian advocate without an adjudication of incapacity for a person with developmental disabilities if the person lacks the decision-making ability to do some, but not all, of the decision-making tasks necessary to care for his or her person or property, or if the person has voluntarily petitioned for the appointment of a guardian advocate. So, to know whether the person is going to qualify, we need to know what a developmental disability is. A developmental disability means a disorder or syndrome that is attributable to intellectual disability, cerebral palsy, autism, spina bifida, Down syndrome, Phelan-McDermid syndrome, or Prader-Willi syndrome that manifests before the age of 18 and that constitutes a substantial handicap that can reasonably be expected to continue indefinitely. Another thing that distinguishes this type of guardianship is that the guardian is not required to be represented by counsel if the guardianship is of the person only and the only asset of the ward is government benefits, where the guardian is the representative payee. Now, when it comes to filing the petition itself, the petition to appoint a guardian advocate, the notice must be given to the person with developmental disability, both verbally and in writing. The next of kin must also be notified. Within 3 days after a petition is filed, the court is required to appoint an attorney to represent the person with developmental disability who is subject to the petition to appoint a guardian advocate. As a practical matter, the majority of the guardian advocate cases that I've presided over as general magistrate have been handled by Three Rivers Legal Services in our community. They represent the guardian, and then Regional Conflict Counsel is appointed to represent the person with developmental disabilities, who is ultimately called the ward. Now, this has been an overview of what a guardian advocate is and what is required to file for one. If you found this information useful or you know somebody that could benefit from it, please like and share, and definitely follow the campaign's social media. Do you have a particular topic that you would like me to address? Send a message through the campaign's social media or website, and I'd be happy to film a video on a topic. Just remember that I can't talk about a specific case or specific facts. If you miss an installment of Scales, visit the campaign website to see all of the Scales videos that are available. And please remember, on August 23rd of 2022, I'm asking you to vote for me, Jennifer Kuyrkendall Griffin, for Suwannee County Judge.